Good morning. I'm Ben Alinsky, CAP's Senior Vice President for Structural Reform and Governance. Thank you for joining us today. We have a great discussion for you on the Supreme Court's recent decisions with an absolutely all-star panel. Yet again, the Supreme Court's 2024 to 25 term saw a far-right majority on the court continue their trend of reducing rather than expanding the rights of Americans. But this shouldn't be a surprise. In 2022, Dobbs took away a long enshrined constitutional right to choose from women across the nation. In 2023, Students for Fair Admissions undermined decades of progress in ensuring the 14th Amendment was fully implemented for all Americans. In 2024, in Trump v. U.S., the court effectively rewrote the Constitution, creating out of whole cloth a new sweeping presidential immunity. And this term, we saw it again in cases ranging from Scrimetti to Casa. Gone are the days when the court served as a neutral arbiter of the law merely by calling balls and strikes. The majority is guided no longer by precedent or reason, but by political and ideological preference, remaking the country in its desired image, case by case. Today, we want to focus not only on the key merits decisions issued this term, but also on the many, many decisions issued via the so-called shadow docket. Indeed, this past term may well be remembered as the term of the emergency appeal. Over the past few months, the Trump administration has used the court as its own personal tribunal, seeking emergency action to stop adverse lower court rulings in the hopes that the justices would prove more sympathetic than their district and circuit court colleagues. And sure enough, time and again, the court sided with the administration, blocking lower court stays through unreasoned, cursory rulings, permitting the administration seemingly illegal and unprecedented conduct to proceed on generally procedural or technical grounds. In doing so, this court further expanded the powers of the presidency, to the detriment of constitutional powers specifically granted to Congress and the courts, in a manner wholly rejected at the founding of our nation. In doing so, they have rarely said a word about the underlying merits of actions the Trump administration is taking that are violating deeply held constitutional rights. And in doing so, they have given their permission to effectively continue trampling on those rights with real-world harm and potentially irreversible consequences. Through Trump v. Casa, the 6-3 majority ceded the court's power to issue nationwide injunctions, making it much more difficult for everyone in America to stop the government from violating their constitutional rights. As Justice Jackson said in her dissent in Office of Personnel Management versus American Federation of Government Employees, the court has, quote, demonstrated enthusiasm for greenlighting this president's legally dubious actions in an emergency posture. In that case, the court gave the Trump administration the green light to create the framework to dismantle large swaths of government agencies and fire tens of thousands of federal employees, despite the seeming illegality of the executive order that is at question. In DHS v. DVD, the right-wing majority is permitting the administration virtually unfettered power in the immigration space, going so far as seemingly permitting the removal of immigrants to third countries, like Libya or South Sudan, where they are at risk of death, torture, or other prosecution without opportunity for a hearing. Medina v. Planned Parenthood lays the groundwork for conservative states to defund Planned Parenthood, which provides crucial preventive care for millions of women across the country at a time when Congress also just made historic cuts to Medicaid. U.S. v. Scrimetti will limit the ability of all people, transgender or not, to get the medical care they need. And Mahmoud v. Taylor opened the door for parents to challenge classroom curricula across the country if it does not fit within their own beliefs. This is just a snapshot of some of the cases handed down by a Supreme Court taking great pains to appease a president who acts above the law and is trying to stop Americans from pursuing their rights against the government and from special interests. And that is why Congress needs to reassert its power as a co-equal branch of government, arguably a first among equals, in fact. This starts with 18-year term limits and a binding code of ethics for Supreme Court justices, but Congress must also look to end judge shopping, put new transparency and procedural safeguards on the shadow docket, and to pass laws reversing some of the drastic holdings in Trump v. U.S. and Trump v. Casa. Now I'm going to turn it over to our esteemed moderator, Madiba Denny, deputy editor and senior contributor of the legal affairs website Balls and Strikes, and the author of The Originalism Trap, How Extremists Stole the Constitution, and How We the People Can Take It Back. Madiba, thank you so much for joining us, and I'll turn it over to you.
Thank you so much, Ben. It is a pleasure to be here with all of you, although I wish it were under better circumstances. So I would like to take this moment to introduce the illustrious panelists I'm very lucky to get to speak with today. With us, we have Leah Littman, a professor of law at University of Michigan and author of the New York Times bestseller, Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. We also have Aaron, sorry, Aaron, I'm gonna butcher your last name. Aaron Reichlin Melnick, senior fellow at American Immigration Council, as well as Anthony Michael Crease, associate professor of law at Georgia State University. And I think also congratulations are in order for a new dean position. Yes, congrats. Also, everyone, this is an extremely condensed version of all of these folks' bios because they are extraordinarily impressive and I don't have time to list it all. So speaking of not having time, let's go ahead and dive in. I know that the Supreme Court has given us an abundance of material to work with for discussion about how it, generally speaking, sucks, and speaking more specifically, has been functioning as the judicial arm of the presidential administration. But since we do not have absurd amounts of time, I'm going to ask for my first question for you all to do something kind of difficult. Could you each please identify just one or two cases that the court decided this term that you found the most egregious and say why? We can take these in, I guess, the order I introduced you. So we'll hear from Leah, then Aaron, then Anthony.
Picking one is really hard. Aaron, I'm sorry if I am going to pick the one that you were going to name, but I would probably say Department of Homeland Security versus DVD, the third country removal decision. That's an instance where the Supreme Court blocked and then clarified it had blocked some lower court orders that had directed the administration to provide some semblance of due process to individuals that were about to be removed to a third country where the individuals alleged they would be at risk of violence, torture, and death. Part of what made the Supreme Court's decision, I think, so appalling is this is one of the lower court orders that the administration had clearly defied, in my view, at least twice. And so by removing the government of its continuing obligation to comply with a court order it had already defied, I think the Supreme Court pretty clearly signaled that the administration is going to face no penalty for defying lower court orders, invited more of their defiance with lower court orders, and suggested that the real problem here in our constitutional democracy is not the executive branch shipping people off to places that are on the brink of a civil war or where they are at risk of being trafficked or sold into slavery, but instead lower courts deigning to try to prevent that by holding the administration to its legal obligations.
Yeah, I think that's a really good point, Leanne, that it's not just okaying these bad actions, but really paving the way for more of them. And I neglected to mention this earlier, but for folks who are tuned in, you can click on the show captions button at the bottom of the screen, and you can have subtitles for everything we're saying. So with that, Aaron, I'll hand it to you.
Yeah, well, as you noted, Leah, I obviously want to say DPD, but I'm going to go a slightly different direction here and really focus on the cases where the Supreme Court has allowed the Trump administration to strip people of status, which is Noem v. National TPS Alliance and Noem v. Doe. In those cases, the Supreme Court blessed combined the Trump administration stripping over 500,000 people of legal status. And the most egregious aspect of this, beyond the human impact of it, is their total failure to explain why. In each of those cases, the plaintiffs had very strong legal arguments. The district court and the circuit courts upheld the decisions, and it seemed that there were very strong legal reasonings why the government should lose on this, especially looking back to Trump 1.0 decisions like Department of Homeland Security v. Regents, where the DACA rescission was overturned. And yet here the Supreme Court allows the administration to go forward with mass stripping of legal status that it prevented in its first term and yet offered no explanation whatsoever, which is particularly egregious given the number of similar cases that are still working their way through the system and are still being adjudicated, leaving the lower courts absolutely no guidance as to explain why these decisions were overturned, given that there were 6 or 7 different potential reasons why the Supreme Court could have ruled in the government's favor. And that leaves the admin with even more discretion to take away status and impact people in ways that are immediately felt. Hundreds of thousands of people have already lost their deportation protections and their work permits based on no explanation whatsoever from the Supreme Court.
Yeah, there are two things I want to highlight there. One is that I think people, when we think about people being undocumented, I think most people don't consider the fact that you can become undocumented, that you can have lawful residency, and as the Supreme Court did here, it can just sort of enable it to be taken away. And I also want to really highlight what you said about the absence of guidance, because it's not as if if the court said why it was denaturalizing people, that would have just made it okay. But we're also just now in the position where it further empowers the executive branch to do anything, and lower court judges and the people who had this sort of temporary protected status as well just really have no idea where they stand. Don't know how to move forward, don't know what their rights are. So Anthony, to you.
Well, I would also be tempted to say DHS versus DVD, and I'll briefly explain why, and then move on to what I'll give my more robust answer for. But I think first and foremost, it is just a travesty and a violation of human rights to send people to third-party countries that are incredibly unstable and where they are at risk for being tortured, abused, and God knows what. And I think also what makes that case particularly egregious for me is the pattern of lies that we've seen from the Trump administration, namely for me, from the Abrego Garcia case, where we were told for weeks and weeks and weeks that the Trump administration had no jurisdiction over foreign prisons. And then we find out from foreign entities that, in fact, the U.S. has exercised some degree of jurisdiction over those prisons all along. So the administration seems to be less than truthful with the courts, which I think comes as no surprise to most people who are watching this. But I think Skrmetti, for me, might be the next one. And I'll say that because for two main reasons. One, the decision in Skrmetti, which is a terrible decision as far as I'm concerned, that's anti-trans and will portend a lot of anti-trans cases from the federal courts going forward. It leaned into the kind of legal reasoning that was rejected in Loving versus Virginia, where the court essentially says here, it's okay to discriminate against trans children or perhaps trans people more generally, so long as you're treating or mistreating everybody equally. And that's just something that is a bedrock principle, or I should say a rejection of a bedrock principle of American constitutional law. So that reasoning itself, the fallout from that decision is very concerning to me. Now, folks might say, well, what might that have to do with presidential power or executive authority? And I think what makes this so dangerous, at least in my view, is that this administration, the Trump administration, is not a friend, is not an ally of LGBTQ rights broadly, and certainly in a more acute way, transgender civil rights. And I think this decision certainly empowers them, or at least encourages them to continue to enact or adopt and promulgate policies through the administrative state and the like that are discriminatory, and perhaps it seems more likely than not now that they may very well get away with it when it goes to the federal judiciary for review. So my concern there is both the Supreme Court enabled and blessed discriminatory legislation on a state level, but also now it gives, I think, more power and perhaps more credibility, at least from a doctrinal perspective, to the Trump administration's efforts to roll back LGBTQ rights and specifically transgender rights on the federal level.
I think that's a very interesting point, Anthony, about sort of granting legitimacy, in that it seems like we can see what the administration is doing is wrong. We can see how it's hurting people, and we can see how it is, to borrow Leah's term, lawless. But when the court sort of blesses it in this way, it gives it the imprimatur of they're doing something legit here, as if this is actually fine. This is business as usual. And I also think I want to highlight how you mentioned Loving versus Virginia, because I think that's been slipping through the cracks a bit, even though it is precisely the same thing. Here, the court is saying oh, we're not discriminating against trans people because no one can get hormone therapy if they have like gender dysphoria. And it's just like in Loving versus Virginia when Virginia was saying, like this isn't discriminatory because no one can marry outside of their race and everyone is free to marry inside of their race. So it's fine. This is a tired, old, rejected argument. So there are a couple things I thought were consistent in all of your answers. First was that you all cited cases that were discriminatory. We had the government either discriminating against non-white immigrants or discriminating against trans people. You also all cited cases that are going to get people killed, basically, whether it's because they didn't have the opportunity for a credible, fair interview, or in the case of the shipping people off to literal war zones, or they're being denied life-saving medical treatment. And in also all of the cases, there was either no reasoning or rejected reasoning. So not actually proper, legitimate explanations. And I think, Leah, this goes to your new book about how the court is not actually making decisions based on law at all, but on vibes, and those vibes are bad. So I would love for you to elaborate a bit on what you make of this and what you think are the implications of them either not explaining themselves or giving sort of nonsense reasons.
Yes. So two things that I would say. One is on not explaining themselves at all. I think there's some outside possibility that they don't even really know why it is they are doing what they are doing. It's just that the vibes kind of seem off to them in the lower courts ruling against the Trump administration so many times. If you think about, for example, recent hearings in the House and the Senate, where you will see members of the Republican Party putting up these charts that say, oh my goodness, look at all of these lower courts ruling against the Trump administration. Isn't that a sign of lower court bias against the Trump administration? To which the response is, well, one possible alternative explanation is they're just doing many more illegal, lawless things. And so I think the court is blocking these lower court orders without forcing itself to really articulate why it thinks the lower court orders are impermissible. I think this puts lower courts in an exceptionally difficult situation and is absolutely affecting their decision making. Going back to the third country removal matter, the government filed a motion to clarify at the Supreme Court that the Supreme Court's initial block of the preliminary injunction in the case also paused the lower court's remedial order that had required the government to afford credible fear interviews to the men it had attempted to ship off to South Sudan in violation of the lower court order while those men remained abroad. The Supreme Court added, yep, we also blocked that order as well. Once again, not explaining why any of the initial orders were improper. So what happened this last weekend? The men made a final attempt at relief. They filed a new set of claims challenging this expulsion on Eighth Amendment grounds as cruel and unusual punishment, as well as other legal claims. And one district judge in DC, where they attempted to file, said, obviously the government cannot do this, but I don't think this case belongs with me. I think it belongs to the court that issued the initial order. So the case went there. What did that judge say? That judge issued a minute order saying, I interpret the Supreme Court's order as basically barring me from doing anything here, even though, again, these are different legal claims. And this is something that Justice Sotomayor, I think, warned about in her dissent from the third country removal case. And she said, look, if the Supreme Court's goal is to just stop the lower court from adjudicating this case or doing anything, fine, but at least explain yourself. And their unwillingness to explain themselves is creating this deterrent and this signal to the lower courts that you're doing something wrong, stop, but we won't really tell you what it is. On the reasons that they do provide being bad reasons, I mean, you look at the flexibility of the legal standards that the court has adopted. And I think what that does is it provides them with the flexibility to do what they want in future cases without actually having to apply the legal rule or ostensible legal rule they formulated in a principled way. So think about, for example, the reasoning in Mahmoud versus Taylor. That's the decision about whether parents have the right to notice and an opportunity to opt their children out of instruction that they are involved LGBTQ characters, LGBTQ inclusive storybooks. And Justice Alito's opinion for the majority flew off a few terms that said, okay, well, when the burden is of a certain character, what character? I don't know. When the instruction is an objective, real threat or danger to an individual's ability to raise their children in accordance with religious beliefs. Well, what is an objective threat in the form of instruction? Then he added, well, when the storybooks have a normative message. These are all such flexible, capacious terms that it allows them to give opt-out rights to groups or parents that they would like without then applying that decision in a coherent or principled way. So bad reasoning, like where the reasoning is just kind of hand-wavy vibes or no reasoning, all of this, I think, enables different kinds of lawlessness.
Yeah. And, as you're saying, talking about these sort of billboards or the poster boards that Congress members come out with and say, isn't this a problem that a sign of bias that the lower courts keep blocking the administration? It's kind of like saying, I feel like the cops have a grudge against me because every time I rob a bank, I get arrested. Like, what's the deal? And it doesn't, that's not how things are supposed to work. And it's producing this chilling effect on lower court judges, you're saying, and also sort of like a shell game for everybody else trying to figure out where they're supposed to go. What rights do they have? Excuse me. And something that also strikes me as interesting as you're talking about the flexibility of the standard is, do we have legal tools right now that are really capable of responding to this moment? Or is it, not so much a matter of what tools they are, because people will do whatever they want with the tools they have? That might be some of a question for you, Aaron, since I think you're the one of us on this call who's like actively working at a place that's like actively litigating some of these cases.
Yeah, I think when you look at CASA, which is the case which struck down nationwide injunctions, you see that the tools which advocates have to challenge these actions are being limited. Of course, both Kavanaugh and Sotomayor, in concurrence and dissent in that case, emphasized that class actions remain as a tool to fight back against these actions. But in the immigration space, where we do most of our work, class actions are actually heavily limited by Congress. In 1996, Congress stripped federal courts of jurisdiction to hear certain immigration enforcement-related class actions. That doesn't mean everything touching on immigration is somehow impossible to litigate class actions, and we're likely going to see class action injunctions in the birthright citizenship case. But it does mean that one of the tools that was out there, the nationwide injunction, is now gone. And with the Supreme Court also issuing these unexplained decisions, the tools that litigators have to challenge unlawful policies are more difficult. As the DVD example really shows, after bringing that completely separate set of claims, Judge Murphy in Massachusetts still threw up his hands and said, well, I think that the Supreme Court was effectively saying, no matter how I try to address this, I can't do anything. And you could have had a federal judge going the other way. You could have had a federal judge looking at what the Supreme Court said and saying, well, there is no precedential value to this. But when the court has stepped in twice, I think it sends a message. And that message is, it doesn't really matter what you think the law says. We just don't think you could do this no matter what. And that offers very little guidance for litigators and makes it very hard to challenge these kinds of policies. And I think that is a legacy coming out of this court, is that the tools for civil rights litigation are drying up. Of course, Justice Roberts and many other conservatives on the court have long thought that the Warren Court era of widespread judicial activism, as they would frame it, was wrong and should be rolled back. And they are choosing to do this, of course, at a time when the executive is engaged in the greatest degree of power using of any executive in the history of the country. And so that's really an unfortunate time for the judiciary to be sitting back and saying, well, I guess really, when you get down to it, there's not much we can do. But tools do remain available, and litigators are creative, as are district court judges, and you will still continue to see some victories here in the courts. This doesn't mean that all is lost, because that's not true.
Yeah, that's so important for people to remember. I think there's a tendency towards doomerism, which is understandable because, yeah, things are pretty horrendous. But things have been pretty horrendous before, and people still fought, and sometimes people still won. So that doesn't actually mean that things it's just a wrap for us now. And I do think you also raised a really good point about the sort of timing with this comprehensive rollback that we're seeing. I think a lot of people had that reaction to the nationwide injunctions in Trump v. Casa, sort of saying, really, like this is when you choose to say nationwide injunctions are bad, after all the other nationwide injunctions, after all the things that you allowed to happen. Now, when the executive is trying to single-handedly rescind the 14th Amendment's guarantee of birthright citizenship and take us back to this slave era understanding of citizenship instead. Now you're choosing to say that nationwide injunctions are a bad idea. It's pretty like transparently not actually about the law, not actually about principles, but about pure politics. And with that, I think, Anthony, I'd love to hear from you here, since I know that in your book last year, Rotten Revival, you spoke about how historically politics is what makes constitutional law. So can you talk a bit about like what the political forces shaping constitutional law are today, or what they were before that we're now seeing the repercussions of?
Yeah, sure. So let me break this down maybe into three subcategories, which is I'm thinking about the moment that we're in terms of broad historical arcs, right? So what are historically inherited principles that are important to us in our constitutionalism, and how are they playing out today? Then I'm thinking about institutions. What is the role of the court? How does the court function? What is the court supposed to be doing? And then I think of the law as something maybe, right, that's, I think, interrelated and interconnected with those other two things. But what is the purpose of the law, particularly when it comes to like injunctive relief and kind of stepping in when big changes are being pushed by the executive branch? And I think to the first principles thing, it's really interesting. We're sitting here a few days after the 4th of July and many celebrations over the Declaration of Independence. And, to me, there are two big informative periods in Anglo-American history that we really should be thinking about today that the court has just, I think, ignored and done a great disservice to this term and last term. And so I think of two periods. I think of 1688 and the Glorious Revolution, the toppling of James II. And I think of the American Revolution and the grievances that the American colonists had against the British government, King of England and Parliament. And so many of the grievances that the Englishmen had in 1688 and colonists had in 1776 are things that we're seeing this administration do today. Let's just go through a few of them. So first is the president running roughshod over Congress and really doing damage to Article 1, dismantling governmental entities and agencies without the benefit of law, right? Without having legal backing to do so. The Trump administration threatening governors, threatening the city of New York if they don't elect the mayor that he prefers them to elect. The deportation of individuals without due process and sending them overseas for proceedings. The abuse of the military, which we've seen through the abuse, I think, of trans service members, the deployment of troops in Los Angeles, the attack against academic freedom, particularly at Harvard and Columbia, but all across the United States, the use of kingly power, and here I'm thinking about the immunity decisions, the attacking of the judiciary of itself, lying to the judiciary and making false representations to the judiciary to undermine other checks on his power. These are all grievances that the English had in 1688 that gave the Declaration of Right, which is right the kind of a forerunner to our Bill of Rights. Right, these are things that the English rejected in the 17th century. These are similar things that our Declaration of Independence rejected as lists of grievances, right? An indictment against the British government that gave us the birth of our nation, and eventually were things that were reflected in the Constitution, but also the Bill of Rights. And here we are with the court just not caring, right? Not thinking about these first principles. And I think that's a real travesty just in terms of our constitutional development. And it's a real, I think, abdication of taking history seriously. This court loves to do history, but only in their particular way. And it's bad history, right? And of course, we're speaking to the expert of that, right? They do terrible things with history. And I think this is the moment that they should be thinking about history. They should be thinking about that longer trajectory of jurisprudence. But then I think about what is the institution of the court, the Supreme Court, supposed to be. And forever, the Supreme Court has reflected the dominant political coalitions, the dominant ideologies of the period. So it is a creature of politics to the extent that, right, the Supreme Court justices are nominated by a president. They're confirmed by the United States Senate, right? All of these people are elected. And so electoral politics and the kind of politics of the judiciary all play a role. And so it's not a surprise that the court tends to be majoritarian, right? The court tends to work in lockstep with the dominant views of the day. And I think that's what we're seeing now, right? We have a court that has been largely fashioned by George W. Bush, by George H.W. Bush in the case of Clarence Thomas, and with the three Trump nominees. This is a solidly right-leaning court. And so they're going to do things that are consistent with the Trump administration's goals. So it should not be a surprise to us, I think, that they're not really a meaningful check. But that said, it comes to the third question, which is, what is the point of law in the first place? Even if I think the court ultimately comes out with decisions that I don't agree with, and they come out, they come with outcomes that I find to be grotesque and objectionable, what they should be doing is upholding the process, right? And so there's been a complete abdication of the process where we get rulings without any explanation. We get these kinds of knee-jerk reactions when the court is supposed to preserve the status quo until the litigation plays itself out, right? The whole point, I think, of equitable relief is maintaining the status quo until you sort things out to prevent harms that you cannot undo. And the court just does not care. You go over to a third country and something happens to you, sorry. You lose your job, but you probably shouldn't have. Well, that's unfortunate. And then it's just over and over and over again. They don't engage in the balance of harms. They don't engage in that kind of equitable principle or the equitable principles that we all learn in law school, and they don't explain why. And so, to me, that is just an abdication of their role as a court, but it's also just a real questionable deviation from how law is supposed to operate just from a basic procedural viewpoint.
Those are excellent points. Emotionally jarring points. Thinking about the extent to which we've seen the abandonment of the process, but the abandonment of that process produces like substantive harms. So it's not just a matter of, checking boxes, following rules. There are actual real bad things that happen from this. I also recommend to folks tuning in to maybe give the Declaration of Independence a reread, because Anthony was spot on as he was talking about many of these grievances that the colonists listed as reasons for rebellion sound awfully familiar. Just like a lot of the things we're seeing right now, and this speaks to as well some of the court's selective use of history, which I write about frequently, in that they're sort of like picking and choosing which parts to pay attention to, which parts they think are worth anything, because these are long recognized grievances. These are things we established were wrong ages ago. And I think that's a part of why I personally feel like this is one of the worst eras of the Supreme Court, and that when I look back at previous harmful things the court did, I think, at least then when they did those bad things, they didn't have the benefit of like 160 years of precedent saying this is wrong, by the way. But we do have that. And so it makes it even more flagrant, even more sort of ridiculous, really, to see the court indulge this sort of like lawless, anti-democratic behavior. And so with that, I would love to hear from any of you. Please feel free to chime in on this one. I think we've been like circling around an idea a bit that I think recurs throughout history as well. This idea of sort of like a prerogative state. This was like a decade ago. This was sort of like a viral idea saying, there are in groups who the law protects but does not bind, alongside out groups who the law binds but does not protect. And, several decades before that, there was like a strongman, quasi dictatorship, like president. And I want to say it was Peru, who said like, for my friends, everything, for my enemies, the law. So there's this idea that, the law can help some people, but is not actually here to help other people. So I would really appreciate you guys to talk a bit about this idea of, some folks get norms, other people just get the whims of the executive branch, and how the Supreme Court is helping to construct this two-track system. And like, what is relief, especially on the emergency docket, when we're talking about like the equities, what is relief like for normal people versus what is relief like for Donald Trump?
Well, I'd love to jump straight in on that, because immigration is in many ways the field of law that affects the most number of people, in which the law does bind but basically does not protect. Of course, there are protections in immigration law, but they are by and large the protections that Congress itself had written in. And for the last 150 years, since the creation of the plenary power doctrine in the late 19th century, immigration has been this state of exception to a lot of the constitutional norms that we accept. Now, of course, that doesn't mean that immigrants are not entitled to due process, but infamously, the process that immigrants are due is largely the process that Congress has provided. There are some exceptions for people who have developed deep ties to the community, but we have seen the Supreme Court even say that the suspension of habeas is legitimate for immigrants who have crossed the border recently. And Congress has stripped the federal courts of their ability to step in and validate the rights of immigrants in the United States in ways that would be pretty unacceptable in any other context. With immigration in particular, there is a century of law that Congress has put on the books, much of which has not been used for generations, that the Trump administration is reactivating. One great example of this is registration, this process that was put in place during World War II, requiring all non-citizens to register with the federal government and carry with them proof of registration at all times, at threat of criminal punishment, jail, and fines if they fail to do so. That was effectively never enforced. Briefly enforced during World War II, but for the last 60 years has been a law on the books, but nobody's done anything with it. And now the Trump administration came into office and they said, we have the internet now. We're just going to put up a registration process on the internet. Now, anyone who wants to register can just go online and they can register and get themselves a fingerprint appointment. And if they fail to do so, they have willfully failed to register, and that means we can arrest them. And that instantly criminalized 2 to 3 million people who would have to choose between, if they knew about this, coming forward and self-incriminating in some ways about their status, or not coming forward and self-incriminating for failure to register. And the court is likely to endorse something like that because immigration is unique. It's different. It is the area where the state is allowed to strip rights away. And I think what we have seen in the Supreme Court over the last 5 years, not starting new here, is the court increasingly say the constitutional norms that limited us in the past, some of which we gave, exceptions, we found ways around this, we said jurisdiction stripping has to be very specific and unique here, are no longer applying, because I think you see the court wants to let the government do this. And when we talk about letting the government do this, we're talking about the deportation of 4% of the US population, which again, by law, the government is authorized to do. And I think that is the challenge here. Congress has allowed the government and given explicit statutory authorization to the government to do a lot of things that the average American member of the public doesn't want to do, even if they endorse this idea of mass deportation in general. And the court, we have seen now say, we're going to take those laws seriously. Whereas in the past, they may have read exceptions into the laws. The infamous example is Zadvitas in 2001, a Supreme Court case where this court read a 6-month limitation on detention into the law that simply didn't exist. They just wrote new words into the statute because they felt doing otherwise would cause a constitutional problem. And that era of the court is gone. And now they are no longer reading exceptions into laws to sort of validate basic constitutional principles like you were talking about that date back centuries, that really validate these ideas of what it means to be an American system of law. Now the court is saying, we don't really think we have to do that. Mass deportations are legally authorized, even if they're cruel, even if the results are poor, unless there is a very clear statutory issue or something like the Alien Enemies Act, where it's extremely obvious that this law is not being used appropriately. We're just going to let the government do whatever they want and sort of damn the consequences. And you see Sotomayor and Jackson calling those out in the recent decisions.
If I could just say 2 quick things.
Oh no, Leah's 2 quick things.
Maybe I'll say 2 quick things.
Okay.
I think the thing that really at least bothers me in the future going forward is what we're seeing with universities in terms of the Trump administration. You know, if you play ball, you get what you've been entitled to, but if you don't, you're going to have things taken away. And it's, you know, it's very much, you know, this idea of, you know, kind of taking a receivership of some departments at certain universities in order to bring back federal funding. And then people, you know, like for example, Columbia will say, okay, we agree to all your demands, and then, oh, well, that's not enough. And so it's just, right, it's just a kind of a constant thing. And again, you know, we've had this in our history, right? We've had these kinds of things where the royal prerogative was used unlawfully against, you know, Magdalen College in Oxford, right? We've seen this before. And so, but it's very much of that kind of mentality of, you know, if you play ball and you're my friend, whatever, you get what you want. But if you don't, you know, you're going to have to pay for all of that.
Yeah. I think you know, we were sort of talking about how the court used to have some degree of like willingness, like Aaron was saying, to you know, read things in or like extend more fairness or give an exception. But now to the extent we see exceptions, they're only for the executive to do more illegal activity, and we're just seeing this basically bullying, like with the universities, and also I would say with many members of the media, right? Like we're seeing these settlements that seem to be gussied up protection racket money. Leah, we lost you for a second, so let's get to you real quick.
So sorry about that. I don't know what happened. So what I was going to say is 2 quick things. One is just as examples of the phenomenon, Madiba, that you asked about, the prerogative state, and Aaron talking about in the context of immigration. I think you can look at this past term and see the Supreme Court making it easier for certain litigants to file cases in their preferred courts, get the remedies they want, and harder for other litigants to do so. So we've already talked about in the birthright citizenship nationwide injunction, you know, choosing this particular moment to limit one of the remedies, the nationwide injunction that have been issued in many of the major civil rights constitutional cases involving the administration, at the same time, not allowing Medicaid beneficiaries and providers to sue to challenge states' decision to boot certain providers out of the Medicaid program in violation of federal law. You know, Justice Jackson, in her birthright citizenship executive order dissent, noted that the victim of the Catch Me If You Can regime that the court had potentially created would be the poor, the uneducated, you know, the powerless. Then, in the set of cases involving corporate interests, the Supreme Court makes it easier for fuel producers and corporate interests to challenge, you know, the EPA's regulation of climate. And Justice Jackson, again, in that dissent, talked about how that was giving rise to the perception of the court protecting moneyed corporate interests. The court allowed, you know, tobacco manufacturers to basically choose where they can challenge FDA regulation by allowing them to basically pick, a gas station or grocery store anywhere to actually file the challenge and opt to do so in the Fifth Circuit. So you look at that entire set of rules, and it's really hard to get around the idea that they are make it easier for certain rights, certain litigants to protect their interests in the judiciary, and harder for certain litigants to enforce certain rights to do so. But the premise of your question about the prerogative state, I'm sorry if someone had already pointed this out when I was absent, dates back not just to conversations about, outgroups, in-groups, binding and protecting, but Ernst Frankel's book, The Dual State, which is by a lawyer who is describing in real time the functioning of the Nazi regime and how that operated. Frankel talked about how there was a dual state, what he called normative state and a prerogative state. And the normative state was where the ordinary operation of rules remained in effect, and it allowed individuals to imagine that the rule of law, right, the legal system, still operated because in their interactions, right, in their everyday life, it still seemed to work. But then the prerogative state was the one where, on certain political issues or involving government officials or political powers, there the courts and the law, right, declared states of exception, authorizing emergency powers. And there really was no law governing this besides, the political party gets to advance its political ideology in whatever way it wants. And I think, if you are wondering whether our regime, right, has certain parallels to the dual state that Frankel decides, I would point you to a footnote in Justice Jackson's dissent in the birthright citizenship case that cited Frankel, dual state, in talking about the regime of executive lawlessness that the court had ushered in.
So I'm going to have one more question of my own, and then I want to turn to questions we've received from the audience. The last question I have is, so it really gets to what we've talked a bit about some of these dissents and these warnings that especially Sotomayor and especially Jackson are trying to give. Like, these dissents are coming basically as close to a Supreme Court justice is willing to get to be like, America, you in danger, girl. But we also see some like resistance to this idea. Like, we'll get, every so often, a comfortable law professor will say this is actually fine, or this is in accordance with the law, which Aaron, you pointed out sometimes, the law does allow some of this stuff, but that doesn't mean it's okay. But they'll say it to sort of like excuse what's happening, and I think we also see, we see some people sort of adjusting their red lines, saying, if Trump defies a Supreme Court order, then we'll really be in trouble. And it's like, okay, well, the Supreme Court will just always side for him, and then you'll never be in that situation. So I would love to just touch a bit on the gravity and how it is or is not getting through to the public, and just like what sort of conversation should we be having? That was for any of you.
I guess I'll just jump in real quick, which is I think, well, at least from the law professor perspective, is sometimes we try to divorce the law, and then we don't really talk about the context, and we don't talk about the effects of the law, and that's kind of, I think part of that is just by training, and also law professors tend to have a high kind of deferential attitude towards hierarchy, and it's just, if the Supreme Court says so, it's fine. But challenging the Supreme Court, I think, is an important thing to do. Right? It is important to say this is wrong, this is not correct. The law shouldn't be this way. The court should explain itself. Right? We should be critical of the court's decisions in a thoughtful and meaningful way, and we need to be encouraging the public to see the wrongs of what the court is doing. And so I think so long as we're having conversations like this today and on social media and other platforms and other places, I think that's really important to illustrate what the court is doing, why the court is wrong, and what the collateral effects of the court's decisions are.
Yeah, I agree. And also going back to this context of like what the law means here. The law, in my field, the law is systematically biased against immigrants. And that is just the reality of how Congress has structured it. And the fact that the last time Congress made any major changes to the enforcement system was 1996 at the height of tough on crime. So we have a system that produces results that in many people view as unjust. And that is the intent of the system in many ways. So what does it mean then to be litigating these cases? Well, I think you are still seeing that there are limits, and there are times that we can argue, yes, the law, something might be legal, but it violates, statutorily legal, but it violates our basic foundational due process principles, and the law itself might be unconstitutional. And so I think you have to make the point here that even if something is legal, that doesn't mean it's necessarily right. The law can be changed. The law is not neutral here. So just because something is legal doesn't mean it is constitutionally legitimate. Of course, the courts may find otherwise. We may lose on these arguments, but we may lose on procedural reasons entirely unrelated to the claim, because Congress has made it harder, has said that you should lose on the procedural grounds here. And I think that is the challenge here, is trying to navigate this area of saying that things may be legal, but that doesn't mean they're right. And even if they are illegal, it doesn't mean that a court can do anything about it. In 2022, the Supreme Court issued a decision, Aleman Gonzalez, which effectively said that courts may not issue injunctions restraining immigration enforcement policies. And for 25 years, that law had been interpreted narrowly. And in 2022, the Supreme Court said, no, we're going to interpret that as broadly as possible. Even the unlawful operation of an immigration enforcement law may not be enjoined. So that means that we have a situation where the law restricts our options, and we have to go beyond the law sometimes into advocacy and policy and trying to convince Congress to change it.
I mean, I'm happy to add something short. I guess I would just say, I don't think there is like one right way or one right course, right, to try to oppose like what the regime is doing. I guess my general guidance is try to stay out of the way of the people, right, who are trying to reach different audiences, right, or use different media to do so, right? I think there is room for the sort of advocacy and like policy focus, that Aaron is talking about. I think there is room for public education on the law, in different ways. Obviously, I write law review articles, but I also have a podcast in which I speak very differently, than I do in law review articles or the classroom. So I think there are many different ways, to try to get people engaged and invested in the sort of organization and networking that is going to be essential, to push back against what we are seeing.
Yeah. Basically, don't leave power on the table. If they're harming us in a comprehensive way on all fronts, we got to fight back on all fronts too. So I have a question here from Maureen Grope, who's a Supreme Court correspondent at USA Today Network, who points out that there were over a dozen times this term where the 3 liberal justices actually formed a majority with at least 2 of the court's conservatives. This happened in 2 cases involving death row inmates and in other cases involving prisoners or convicted criminals. And also happened when the majority sided with the government on ghost gun regulations and on challenges to the Affordable Care Act, the Universal Service Fund, and the Nuclear Regulatory Commission. So her question for you is, what does this tell us about the court's conservative bloc? Like, what are the issues dividing these 6 conservatives?
So I think that the set of cases, Maureen, that you listed, to my mind, fall into kind of 2 categories. One is the administrative law matters, where I don't think the Republican appointees know exactly what they want to do by way of the administrative state on non-delegation and appointments clause matters. Those are instances where the court opted not to really change the law and to hold the line as is or tread water without ruling out the possibility that they would revisit the issue later. The non-delegation case, FCC versus Consumers Research, I think is one of the more interesting and also frustrating decisions, in that we have had 5 of the Republican appointees say, I would like to revisit the non-delegation doctrine. The Chief Justice had joined Justice Gorsuch's dissenting opinion in Gundy versus United States. He does not explain why all of a sudden he is off the non-delegation bandwagon in FCC versus Consumers Research. And I've been talking about this with some administrative law people, but it's hard to read the court's decision, the majority decision, that is, as a definitive reaffirmation of the intelligible principle standard for the next 5 to 10 years. It reads more like, I don't know, right? We have these possible alternative standards that have been floated. We're not sure we're into those, but not going to rule out the possibility of doing something later. So that's one set of cases where it feels like the justices are treading water because they haven't yet figured out exactly what they want to do, and they kind of want more intellectual firepower or groundwork to lay out what they should do in the future. The second set of cases that you identify, those involving certain criminal defendants, death row inmates, as well as individuals who are detained, I think fall into the category of less publicly salient, less ideologically salient. And there are different coalitions of the Republican appointees that splinter them. And I think those particular cases are what I have called the pro-Kafka versus anti-Kafka wings of the court, where some of the Republican appointees look at, for example, Richard Glossip's case, the case of a man who, again, seems like is probably innocent. And, the Oklahoma Attorney General did not want to move forward with the execution, but was kind of blocked in his ability to do so by, the governor, as well as the Supreme Court, the state Supreme Court, that is. And in that instance, you have the anti-Kafka wing of the court saying, okay, this just cannot be. And again, in a kind of a less politically salient, less ideologically salient setting. So I think, of course, there are some different divisions among the Republican appointees. I think the two that you were gesturing toward, the we're not totally sure what we want to replace the current regime with, and the anti-Kafka, pro-Kafka wings are some of the divisions. But I tend to think that those cases are either drawing one-off exceptions in criminal cases where they say this just cannot be, or treading water, holding the line for the time being. And in that sense, it's always tough to measure what is the objective normative significance of a case. But I think the cases that we are focusing on usher in pretty significant changes to the law or the way our legal system has been operating, or the consequences for people's lives, or, the constitutional rule of law more generally, because of the changes they are affecting, are probably why we focus on them.
I love the framing of a pro-Kafka, anti-Kafka wing. I wish there were an act like you got some sense wing. We also have a question here from Kelsey Reichman, a Supreme Court reporter at Courthouse News Service, who's asking if you can address the court's relationship with the lower courts. You've probably seen that study going around saying that district courts rule against the administration upwards of 90% of the time, and then the Supreme Court just flips that outcome on its head, citing for them 90% in 90% of its cases. So how do we explain this sort of juxtaposition? And what's lost by not deferring to the lower courts on fact-based cases when, the trial courts are the ones that are closest to the facts at hand?
I think, the fact-based word is where I was going to go for here, because I think you saw that with Justice Jackson's dissent yesterday in the case involving the OPM memo on reduction in forces at various federal agencies. The district courts are dealing with incredibly fact-bound scenarios, and they are wading through intense reams of declarations, of administrative records, of depositions and transcripts, and everything that they have to do as part of their jobs. And they are producing decisions that are based heavily on the facts. And then by the time it's making to the Supreme Court, those facts have, as Justice Jackson emphasized, are evaporating from the record. And the cases are being decided with seemingly on extraordinarily abstracted questions of legal authorities. And of course, that is the role sometimes of the court, to decide on abstracted questions of legal authorities. That's not to undermine what they're doing here. But I think her point that they are stepping in these very fact-specific cases where decisions, rest on a variety of factors linked to what is actually happening. And they are deciding them on these abstract records that act as if the facts are not in the record. I think that is the big challenge here, and why you see the district courts ruling the way they are, because they are actually looking at what the Trump administration is doing, and they are seeing the presumption of regularity is gone. The administration is broadly ignoring the courts, or in many circumstances, if not ignoring, simply turning a shoulder to and downplaying, stonewalling, however you want to describe it, slow walking these decisions and these actions. But the court is essentially blessing that and endorsing that, as Justice Sotomayor emphasized in DVD, the third country removal case here. And that means that because district courts are still dealing with the facts every single day, I think they are going to continue to rule the way that they have been ruling. And then if these cases ever eventually make it to the court for a full cert, on a cert petition and get actually argued, then maybe the justices are going to have to explain some of their, glossing over the facts. But for now, on these emergency dockets, especially when they don't even have to explain themselves, they can just treat this in this generality that strips the facts from the situation entirely.
Thank you for that, Aaron. Regretfully, my clock is showing 12:02, so our time is technically should have come to an end. So I'm just going to give you any parting words, say 20 seconds or less, for something last thing you want the audience to take from this.
The ending to Justice Sotomayor's dissent from birthright citizenship, because I will not be complicit in so grave an assault on the rule of law. I dissent. I think it's an excellent framing of the operation of our legal system, at least in the Supreme Court right now.
I would just say that the Supreme Court, has been kind of revered in legal circles for a long time, and I think it's time that we actually are more critical of the court and we have these conversations in a way that really parses out what the court is doing and take it to task.
You good, Aaron? You're like, I said my piece. Okay. Thank you so much. This was a wonderful, fascinating conversation. Yeah, folks, also everyone on this call is extremely prolific posters on Blue Sky. So if you want to follow up with what folks are doing, you can always check us out there and tune into other CAP events in the future. Thanks so much, everyone.